Welcome to Module 21, where we are going to discuss safety and soundness. As I mentioned in the last module, somewhat of a continuation of this idea of bank supervision, as safety and soundness is found throughout the banking statutes, as well as orders that the bank regulators issue when they find problems with the bank. It's a word used very often in the statutes and the regulations, but yet it is undefined. And so I believe the case that we read for this module is one of the better discussions. And so that's why we will sort of explore the concepts through this case. One of the things we've noted is that the regulators, in addition to having authority, of course, over banks and bank holding companies, they have enforcement authority against institution affiliated parties, and that is the nature of the case that we're bringing. And so they can bring it against both the insured depository institution or just the institution affiliated party, depending on where they see the problem and the fault, I guess. So an institution affiliated party is defined by statute, and it includes directors, officers, employees, or controlling stockholders, because those are all thought to be decision-making individuals. It also includes any shareholder who is actively participating in the affairs of the institution. And it also, and this is always interesting for those who get into the role of attorney, appraiser, or accountant, it can include those outside the financial institution, but there is a higher standard. They have to knowingly or recklessly participate in this violation or this breach. And it has to have a greater impact. So it is a harder standard to go after those outside the institution, but it is something that anyone who finds themselves in one of these roles of an independent contractor should really keep in mind. But anyone in this category can be the target of an action by the bank regulators. And the case that we read dealt with the removal authority. And this is very interesting to me, at least, that the bank regulators have the authority to basically ban someone from banking. And in the United States, to ban someone from their profession is considered a big deal. So this is not an easy or something that is done lightly. And so the standards are high. And so, to bring this type of an action, first of all, the federal banking agency has to determine that the institution affiliated party, that's any of those categories I talked about, has either violated a law, a regulation, or a cease and desist order. Anytime they issue an order and it's violated, that is a problem, or any other written agreement, or engaged in unsafe and an unsound practice. Here we see this nebulous concept again, or committed a breach of a fiduciary duty. Breaching one's fiduciary duty, serious. So there has to be an act, and the act must be serious. Illegal, a violation, breach of a duty, or unsafe and unsound. And then because of this action, the bank has to have suffered a financial loss, the depositors have to have been prejudiced, or the party who performed the act has to receive financial gain. So essentially, there has to be either a loss by the institution or its depositors, or gain by the individual. So if you behave badly and you gain financially, that is a serious problem. And because this is a high bar, this act and this effect all must involve either personally dishonesty or a willful disregard for the safety and soundness of the institution. So there has to be sort of what I like to think of as an intent. So you have an act, an effect, and an intent. And all of those are required for this very serious removal authority, this banning an individual from presumably what has been the way they have supported themselves and their family. And so that is the case that we had for the reading for this module. We had the chairman of this bank's board of directors, Mr. Sedman, and we had an officer, John Bailey, and they have petitioned for a review of the order of the OTS. Now, you may remember the OTS was the Office of Thrift Supervision. It has now been abolished and taken over by the OCC. So we would have the OCC, but it's the equivalent of the OCC at this time. And Bailey has been the subject of a cease and desist order. and he's being asked to cease and desist from participating in unsafe and unsound lending practices. Again, we see this word, but it is actually Sidman that has been removed from banking and banned from future participation. And so they are challenging this. And so the court is looking at the order of the bank regulator, the OTS. And something to keep in mind is that this is in the 90s, the early 90s, by the time this case gets to this point. And the OTS was extremely powerful. The OTS is the agency that was overseeing the savings and loans. We had just had a huge savings and loan crisis. And out of that crisis came the OTS. It was actually previously the Federal Home Loan Bank Board. They were abolished. The OTS was created. They were given all kinds of power, and they used that power to sort of set things right. And so we were in a time where they were being very aggressive, and they were taking actions against individuals, which prior to this time was extremely uncommon. So in this case, it was established, and this was not really disputed, that Bailey had approved loan commitments to buy property from sellers in which Sidman had an interest. And you're not supposed to do this. This violated the bank's procedures. And the OTS said, yes, that was unsafe and unsound. He should not have approved these commitments because someone on the board of directors had an interest. And they also said that Sidman had used his position to get a release from his personal guarantee, and he had not notified the board of his interest in these real estate partnerships. And he had also tried to hinder the OTS investigation. I believe he had tried to tell someone not to testify or to testify differently, maybe, or not fully and truthfully. And the OTS said because of all of these, he should be banned from banking. And so they challenged these. These are pretty severe actions. And what we see here is the court really exploring what it means to be unsafe and unsound. And so basically what they said is that it is true that Bailey did something he shouldn't, but they said it was not that abnormal. In fact, it didn't actually result in any losses. It was not prudent, but being not prudent is not the same as unsafe and unsound. And you see here, they use this word abnormal risk. The thing he did did not create a level of abnormal risk. And what you see on the Sidman side was that although much of it was not good, what we see, and this is always the case, it was Sidman's attempt to hinder the investigation that rose to the level of unsafe and unsound. And so that was the one act of all the acts that he engaged in that they really felt rose to this high level. But what we see is that they didn't find all of the other elements there. So even though Sidman did engage in an unsafe and unsound practice, that alone was not enough. There had to be that financial loss to the bank, the financial gain to him, along with that intent. And they just weren't sure that was there, and so they remanded the case. And ultimately, it was not found to be there. There just wasn't enough there for this very, very severe penalty of prohibition and removal. But as I said, the reason I like this case, in addition to maybe just the sort of interesting facts and the illustration of the OTS flexing its muscles in the 90s, is the discussion of unsafe and unsound. Because we see this so often, and if you're in a compliance position, now you don't want to do anything that's unsafe and unsound, but what is that? And so this case looked at prior cases where they said paying excessive dividends, that was unsafe and unsound because it was abnormal risk. The one they talk about excessive advertising, that must have really been excessive. I feel like there had to have been more to that because it seems a little bit unlike the others, but that's one of the cases they refer to. The inadequate liquidity, that is abnormal. The inadequate loan loss reserves, the inadequate capital. These are all things that create a real abnormal risk. As they say, imprudence, breach of a contract, a contingent loss, the things that they saw in this case, those are not necessarily unsafe and unsound. And so this at least gives you an idea that unsafe and unsound means really outside the norm. It's abnormal risk. But it does create a challenge, of course, Because as a compliance professional, you must make sure that everything that a financial institution does is consistent with safety and soundness. But it is a flexible concept and it is very situational. And, do you think you can figure that out? It is not necessarily easy to comply. It's easier if you have a black line rule. But you can probably see from what we've talked about thus far why the bank regulators probably need this flexible concept, because we never know what's going to be new. So I did ask you to look at a couple of the notes that dealt with some of the other actions that give you ideas of what is unsafe and unsound and what really rises to the level where you get these severe public civil monetary penalties. And one was an action against Citibank back in 2020. But we see these are all deficiencies really related to compliance risk management, data governance, internal controls. And in these actions, as I said, that they're required to take certain corrective measures. And these are the types of actions that it's very helpful for compliance professionals to read and become familiar with, so that they can sort of avoid the pitfalls that led to these actions, as well as put in place some of the best practices, which are oftentimes what these institutions agree to in these orders. And so these are really a wealth of information and something that is very important as a compliance professional to be regularly monitoring as well as reading. You may very well be familiar with Wells Fargo. They seem to just get in trouble over and over again, and they've been the subject of many compliance orders. But some of the orders that I want to bring to light here are these orders against individuals. There were a handful of them back in 2020 and then one in 2023, where we have $17 million penalty against an individual, the head of the woman who was in charge of the community banking. And I don't know how familiar you are, Wells Fargo. There's a documentary. I'll try to think of its name and put it in the group. But they basically put in these sales quotas for their employees that were completely impossible for them to meet. But somehow they kept meeting them, and it was because they were opening all kinds of accounts for people that are unaware of it. And it was so widespread and so extensive that it became very obvious that everyone had to know about it. And so here we see a $17 million civil monetary penalty against an individual, an executive, an institution-affiliated party. Previously, there had been another $17.5 million penalty. And then even some somewhat lower level folks getting, hundreds of thousands of penalties against them. Someone in human resources, we have cease and desist orders. So we are seeing the bank regulators engage in a bit more of these actions against the institution-affiliated parties. I can stop sharing this, or at least maybe change what I'm sharing. We continue to see these, and this is really something, if you are in compliance, you would definitely want to sign up for this. The bank regulators, their enforcement actions are all public, and so you get them by email. But this is one that I thought is just sort of interesting. It's someone who is being sort of prohibited from engaging in the business of banking. Here we have an individual who was sales and service representative at a branch, and they appeared to have taken money from an elderly individual's account. And so they then issue this order where this individual is charged with breaching their fiduciary duty. It caused the bank to suffer loss as well as the individual. They caused reputational risk. That's one of the problems. Also, it said it constituted elderly abuse because the individual was a senior citizen. And then the individual then agrees to this. And basically, they are prohibited from participating in any manner in any actions related to a depository institution or a holding company of a depository institution. And that includes even dealing with shares of stock, or really in any manner They are really completely banned from the business of banking. And so these are orders that are, issued on a fairly regular basis. And I mean, as you see in this case, it wasn't a tremendous amount of money. It was under $7,000, but we see the breach of the fiduciary duty of a person in that position, a person, elderly victim. But these orders are really, they're very instructive for compliance professionals to see what kind of remedies are required and what types of actions the regulators go after. This is obviously a bad act, but there are others that are far more nuanced. So this is definitely part of the compliance scheme, is the reading of these, enforcement actions, consent orders. So this really ends our discussion of the safety and soundness concept. Not that it won't keep coming up, but this is our most kind of thorough discussion of it. And I welcome your questions. Thank you.